Good morning, good afternoon. My name is Bruno Jean-Etienne. I'm the ACC co-country representative for Belgium, and together with Jo and Nick from the law firm Lydian, we'll be hosting today this webinar on recent development in distribution channel in international market. Most of you, and we had plus 150 participants, are joining us from Belgium, but we are also at ACC Europe, a pan-European organization, originally coming from the US, and in the Benelux, we have plus than 500 members, and our aim is really to promote and to defend the in-house activity. And next slide. And for that, we have a lot of activities. So we organize webinars, but also in-person event. And most importantly, we have also a whole lot of knowledge which is accessible online. But even more importantly, and you have to book that in your calendar, next year, our annual European Conference of ACC will be organized in Brussels between the 16th and 18th of April. So you will receive more communications on that as we are preparing the conference, but already bookmark yourself for this very unique event where plus than 500 in-house legal counsel will basically join in Brussels and discuss their problematic. Among those, I will say the problematic of agent and distribution. And thanks to Lydian, so for joining us today. Lydian is a regional Belgium firm based out of 3 locations in Belgium, and they are really tailor-made, and we've used them in the past to serve, I will say, international but also medium-sized company, and they are very efficient and friendly. And Jo is a partner in their commercial and litigation department, and Nick Van Heer is also an associate there. So with that, I'll give you a few technical tips. So you will be able to find a copy of the presentation on the right side of the slide under the word handouts. There will be some poll activities, so you will have to answer some questions from the panel. And also, if you have any question, please use the question features of this column. And if in the interest of time we are not able to answer your question, the team of Lydian will make sure that they come back to you at a later stage after the end of this seminar. With that, and without further ado, I'll give the floor to Jo that will start this presentation. Thank you.
Many thanks, Bruno, for this kind introduction, and welcome to everyone on behalf of Lydian, on behalf of myself and my colleague Nick. So the title of the webinar of today, what we're dealing with, is recent developments in distribution channels in an international market. And the first slide is an overview of the topics that we want to cover today. First, of course, important, as the title also suggests, it's a webinar dealing in an international context. We'll frame today's topic in an economic context and then explain first the conceptual difference in terminology between a commercial agency on the one hand and distributorship on the other hand, and more particular in an international context. Secondly, I will also deal with this topic. We will explain the different legal framework of commercial agency versus distributorship, not only in Belgium, but also in Europe, taking into account the European legislation, more specifically with regard to commercial agency and how it has been transposed into national law, not only in Belgium, but we also deal with it in France, Netherlands, and Germany, as this is also of interest when dealing with commercial agency or distributorships in a more international and, in this case, European context. Then I will pass the floor then to my colleague Nick, who will give you a very interesting overview and discussion of recent case law of the European Court of Justice on commercial agency. He will discuss 3 important cases which have been rendered by the European Court of Justice. And then he will also deal with the impact of the revised EU vertical block exemption regulations, which entered into force early this year, on distributorships, where he will focus on the most important new things that you should consider when dealing with distribution agreements, drafting with distribution agreement, also taking into account an international context. Finally, I will deal with some key takeaways to consider when reviewing a distribution channel in an international context. So first, we will start off this webinar with a poll question, and the poll question, this is not so difficult, of course, reads as follows: are you familiar with the legal differences between a commercial agency and distributorship? And you now have 20 to 30 seconds to vote. Thank you. Okay, so the results are clear. Most of you, 75%, are familiar with the legal differences. So I'll take that into account when going further into this webinar with regard to the legal differences between commercial agency and distributorship, and more focusing then on the most important, not only the high level, but also the detailed differences, and focusing also what's different than in Belgium, but also in Germany, the Netherlands, and France. So first will come a brief introduction where we should put today's topics into economic context. And on the next slide, you see a typical example of a distribution channel in the EU, where it's crucial for any company to make its products available to its customers in the various EU markets. And they use then commercial agents and or distributors who buy and sell products on behalf of their clients. And that's one of such a common route, alongside, of course, sales representatives. What we usually see in our practice is that companies, not only small companies, but also listed companies, are unaware of the level of protection afforded to commercial agents and or distributors, not only on the European level, but certainly also on the national legislation, for instance, in Belgium. This lack of knowledge can, of course, be very costly, and there are many examples of companies, especially multinationals, having to pay significant amounts to their agents and or distributors, even if they have acted in accordance with an agreement that they have concluded, where there's a certain notice period, and even there are no contractual provisions providing for any compensation. So this webinar is really designed to give in-house lawyers and decision makers involved in using commercial agents and or distributors anywhere in Europe, including Belgium, when reviewing its distribution channel, an introduction to the mandatory rules concerning commercial agents and distributors and the latest developments in case law and legislation. So move on to the conceptual difference between commercial agency and distributorship. To understand the legal framework of both types, it's of course important to know the meaning of a commercial agency versus a distributorship, more specifically what the differences are. This is also important for the legal framework. A commercial agency, to be briefly explain it, is a self-employed intermediary who has continuing authority to negotiate the sale or the purchase of goods on behalf of another person. And was called the principal, or to negotiate and conclude some transactions on behalf of and in the name of the principal. This definition derives directly from the agency directive adopted in the European Union already in 1986, which we'll cover more in detail later on in this webinar. By contrast, then, a distributorship is defined as an agreement under which a principal reserves to one or more distributors, that can depend, the right to sell in its own name and on its own behalf of the distributor products manufactured or distributed by himself. And this definition derives directly from the Belgian Economic Law Code. So the main differences, first of all, lie in the fact that a commercial agent sells these products in the name and on behalf of the principal, while the distributor concludes sales of products in its own name and on behalf, and that the commercial agent can be limited to only negotiate but not conclude sale of products on behalf of the principal, while the distributor always, of course, obviously concludes sales of products on its own behalf and also bears its own economic risk. So what's the different legal framework of commercial agency versus distributorship? Commercial agency, there's an EU directive on the coordination of laws on the member states relating to self-employed commercial agents. The agency directive, it applies to all 27 EU member states, including also Liechtenstein, Iceland, and Norway. And it had two main purposes: strengthen the position of commercial agents, enhancing the rights enjoying by commercial agents, and harmonize the law of the member states. The aim of harmonization was to remove, or is to remove, differences in legal treatment of commercial agents that hinder competitions in the EU. Where it's here important to underline that the agency directive represents minimum harmonization. This means that the agency directive provides for the minimum level, and that's very important, of protection that commercial agents should enjoy under the agency directive. But national legislators, like for instance Belgium, are free to go beyond the minimum level of protection and introduce a higher or broader level of protection when implementing and transposing the agency directive into national law. And we will see further on that effectively also other countries have done so, not only Belgium, but on multiple occasions. The directive was in fact modeled on the French and German legislation that existed prior to the adoption of the directive, which have traditionally, and we will also see that, granted a broader protection to commercial agents compared to common law countries such as the UK and Ireland. So now, what are the key provisions of the agency directive? The commercial agent, first of all, is entitled to a written contract. That's important. Member states have the freedom to provide that an agency contract cannot be valid unless it has been agreed in writing. And secondly, and most importantly, there's also a minimum notice period for the termination of an agency contract of indefinite duration. And so when it has been commercial agency agreement has been concluded for an indefinite period of time, or a fixed term agreement that has been extended for an indefinite period of time, and the principal terminates this agreement, then the commercial agent is entitled to a minimum notice period. So how is it calculated? It's minimum 1 month for the first year, 2 months for the second year, 3 months for the third, and subsequent years. Therefore, in principle, a long-lasting commercial agency agreement of multiple decades shall in principle be limited to 3 months notice periods, which is of course relatively short. However, and that's important, the parties have the contractual freedom to agree to longer notice periods than the legal minimum, and they have to, of course, also the freedom to establish longer notice periods in the fourth and subsequent years, like Belgium, for instance, has done. Last but not least, the notice period must expire at the end of the calendar month unless otherwise agreed. So the rules in commercial agency, also with regard to termination for cause, are quite strict. So you have to take this into account when terminating commercial agency. Otherwise, you will be faced with a claim for compensation. So when it's compensation or the key provisions, secondly, is the right of the commercial agent to an indemnity or compensation, and there the agent shall be entitled to an indemnity when he brought in new customers to the principal or has significantly increased volume of business with existing customers, from which, and that's important, the principal continues to derive substantial benefits. So that's up to the agent to prove that it's still to the advantage of the principal after the termination of the agency. The agent is entitled to equitable payment that takes into account all the circumstances, in particular the commissions lost as a result of the termination towards the customers. In the agency directive, the remuneration for the indemnity is kept, and that's a minimum protection, at 1 year's remuneration based on the average historical remuneration. In addition, the commercial agent is also entitled to compensation for damages suffered as a result of the termination, and this can be certain costs and expenses made on the advice of the principal prior to the termination. We will think about that. What could that be? That could be specific investments in publicity, in marketing, but it also could be redundancy payments paid to personnel who, as a result of the termination, has to be fired by the agent. So the commercial agency, what's the legal basis of how it has been transposed into Belgian law? It's the law of 2nd of April 2014, which introduced a book 10 in our on commercial agency agreements in our Code of Economic Law. You have the 25 articles, and the entry into force was on 31st of May 2014. But of course, we already had the old law of 95, which also dealt with commercial agency and which transposed the EU directive into Belgian law. So what are the notable differences between, and that's important if you consider or if you have a commercial agent in Belgium, or you consider to conclude an agreement with a commercial agent in Belgium, what are the notable differences between Belgian law and the agency directive? While the Belgian national law has done more or less a copy-paste of a large part of the provisions of the directive, there are still a few notable differences in which the Belgian legislator has granted a wider protection to the commercial agent. So there was a minimum harmonization, but the Belgian legislator took it one step further. So under the Belgian law, a terminated commercial agent is entitled to a larger minimum notice period compared to the agency directive, when the commercial agency agreement of indefinite duration, of course, is terminated in the third month. In that case, the minimum notice period according to the Belgian law is 4 months. In the fifth year, it will be 5 months, and in the sixth and subsequent years, that's important, it's 6 months. So 6 months is the absolute maximum, although, again, parties have the contractual right or freedom to agree on a larger or longer minimum notice period, but not on a period which is below 6 months if the agreement was longer than 6 years. Secondly, and that's also important, there are special provisions with respect to a non-compete clause, which the agent prohibits to conduct competing, of course, agency activities during and after termination of the agreement. According to the Belgian law, the duration of such a clause is limited to 6 months after termination of the commercial agency agreement. And last but not least, the terminated commercial agreement or agent is also entitled to an indemnity for bringing in new customers, substantially increasing the volume of business with existing customers, from which the customer or the principal continues to derive benefits, and that's called the client or the goodwill indemnity. However, if a non-compete clause has been agreed to, the Belgian law creates a presumption, and that's a rebuttable presumption, that the agent has brought in new customers, increased business volume with existing customers, and this is a rebuttable presumption, so the principal can deny by offering evidence to the contrary. So that was about commercial agency. Very briefly, about distributorship, and that's also very interesting. And very interesting that there at a EU level, there was no harmonization, which gave rise to, of course, different interpretations and applications of the laws and the rules with regard to distributorships in Europe. In Belgium, we have a title book 3, book 10 of the Code of Economic Law, and there are rules, but they are limited on termination of certain distributorships. And these distributorships deal with distributorship agreements of an indefinite duration that envisages both exclusive, quasi or semi-exclusive distributorships, or distributorships where the manufacturer or importer imposes import obligations on the distributor. What are those important obligations? If you look at the case law, that's maybe interesting. It is a minimum stock requirement, after sales requirements, a requirement to have sufficient and qualified personnel, a prohibition on the sale of competing products, and so on. So what's the question if a distributorship is not of an indefinite duration, or is not exclusive or quasi-exclusive, or no important obligations? Then the general civil law will apply. But we see in case law that the general civil law, that there's a tendency also in courts and in case law to adapt nonetheless also the rules on the exclusive distributorships on those other distributorships, especially with regard to the notice periods. So unless in case of substantial breach, a distribution agreement of indefinite duration cannot be terminated by the principal except after granting, under Belgian law, a reasonable notice period. And according to the Belgian Supreme Court, it's not to find an equivalent or a similar distributorship, but it should enable the distributor to find equivalent revenues to the terminated one. The other thing instead of providing for a reasonable notice period, there can also be a payment of a compensatory indemnity, and these equal, or this indemnity equals to the benefits that could have been obtained during the notice period that should have been granted. Thirdly, there's also the possibility in the Belgian law, not only you're entitled distributorship to a reasonable notice period, or then alternatively a payment of a compensatory indemnity. There could also be an additional indemnity due, and this can be an indemnity for the increase in clientele, which will remain with the manufacturer after the termination of the distribution agreement. Secondly, certain costs incurred, the costs which the distributor incurred for the purpose of exploiting the distributorship and which will ultimately be of direct benefit to the manufacturer or importer after the termination of the contract. These are mainly long-term advertising investments, for instance, and the redundancy payments which the distributor is obliged to make to the personnel whom he must release or fire or lay off as a result of the termination of the distributorship agreement, insofar as a notice period to be given to such employees exceed the notice period granted to the distributor. So these are the main important things to remember about the distributorship and the laws in Belgium. What are the rules? If we make now, it's very interesting, I think, if you're considering to appoint also an exclusive distributor in the EU and, for instance, in Germany, the Netherlands, and France, or neighbor countries, what are the differences between on commercial agency and distributorship? This is not an exhaustive overview. It's just pointing out the main differences. If you look at Germany for the commercial agency, there's also, like in Belgium, a right to indemnity for commercial agent unless the agent terminates the agreement by himself, or when the agreement is terminated by the principal for good cause, for a reason when there's a breach by the commercial agent. That's the same. But where Germany goes a little bit further, and that's what I also indicated in the beginning, that there was a larger protection in Germany even before the agency directive. There's a post-contractual non-compete obligation, must be limited to 2 years, and the territory of the customers previously served with the right to adequate compensation in this respect is 50% of yearly commission. So the agent will be entitled, if there effectively is 2 years post-contractual non-compete obligations, to 1 year yearly commission, 2 times the 50%. There's no specific law or regulation with regard to the termination of a distributorship. So there, Belgium, you will see, is quite unique and exceptional. That's always why our principal clients based abroad are very surprised to learn why Belgium has such an exceptional system and what amounts should be taken into account when terminating such a distributorship. But the German distributor has a right to indemnity of the principal under German law, provided he has been integrated in a distribution system of the principal, and when he's obligated to transfer customer data to the principal based on the agreement. And when that's the case, the calculation of the indemnity is based on the distributor's average annual revenue of the last 5 years, as this is considered to be representing the actual revenue during the last period of the agreement. If the agreement only lasts for a couple of years, of course, this will only be the last years then. For France, if we move on, there the commercial agency has a right to compensation for the commercial agent in respect of the damages suffered upon termination of the commercial agency. Case law, however, provides little guidance on how the compensation is to be calculated, but on average, we see that it's equal to 2 years worth of gross commission calculated on the average of the last 3 years. Under French law, parties can agree that their agency contract is governed by the law of a different EU member state, even a non-member state, provided there's a connection with a foreign contract, i.e. there is an international agency contract. For instance, such connection may be that one of the parties is a foreign national, or the agency agreement is to be carried out abroad. Again, no specific law in France that governs the termination of a distributorship, and in contrast, the commercial agent turns in principle no right to compensation for distributor unless such a termination is considered to be abrupt and that no sufficient advance notice period was granted. And that's the same under the Belgian common rules, which also apply in France, but they do not have specific laws with regard to a reasonable notice period or case law in this respect. Then last but not least, the Netherlands, there's also right to compensation or goodwill indemnity upon termination of the agency agreement. He is entitled to an amount of what he has brought in as new customers, or when he has considerably extended the contracts with existing customers, which still yield notable advantages for the principals. It's similar to the client indemnity in Belgium, however, there's a slight different wording. The amount of the indemnity must be fair. That's also like in Belgium, and take into account all circumstances, most notably the commission loss due to the termination, and the amount is legally kept at 1 year worth of commissions paid, calculated as an average of the last years, maximum 5 years, which is also the same as in Belgium. Also in the Netherlands, we have no specific rules or case law entitling the distributors to a goodwill indemnity, but it's possible to seek payment of damages because of an unlawful termination. But this has to be assessed on the basis of general principles of recovering damages, and that equals to the Belgium system, which do not apply to exclusive distributorships. Then finally, with regard to then the territorial scope of the Belgian rules on commercial agency and distributorship. The commercial agency, that's very important. That's the first thing that we have to assess, and when drafting, reviewing a commercial agency agreement or distributorship agreements, what we ask our clients to first check and to determine is, of course, the applicable law and also the place of the jurisdiction. And there it's important that there are also mandatory rules in our Code of Economic Law, and that's that the Belgian court is competent and obliged to apply Belgian law with respect to any activity of a commercial agent which has its principal place of business in Belgium, so which is based in Belgium. Of course, there's also exception. We have also the EU regulations, and if the parties agree to a valid choice of law and or choice of court clause, jurisdiction clause, in accordance with respectively the Rome I regulation and the Brussels I bis regulations, then of course this valid choice will be upheld by the courts, and the courts will then apply foreign law and also confer to the jurisdiction of other countries. But Nick will, with regard to the applicable law and commercial agency, will elaborate a little bit further on the minimum protection based on a very important key case rendered by the European Court of Justice in 2013. In the absence of choice, then there's also a fallback scenario in the regulations, which court will have jurisdiction or the applicable law. With regard to distributorship, there also Belgian court is competent, obliged to apply Belgian law, but there the Belgian Supreme Court has ruled that this will only apply to the part of the distributorship which is executed or performed in the Belgian territory. To the other part, for instance, when you have a Benelux in the Netherlands and Luxembourg, an agreement which has been carried out, then the Belgian distributor will only be entitled to damages or to compensation according with the Belgian mandatory rules for the part of the distributorship which has been executed in Belgium, and there should also be a split then of revenues and so on. And the same exception with regard to also applicable law and the clause referring jurisdiction applies to distributorship. So there it's very important, and that's what we often do, certainly in reviewing in an international context, commercial agency and distributorship agreement, when there's a possibility, of course, certainly with regard to distributorship, to avoid the Belgian mandatory rules, to convey then or refer to the jurisdiction, for instance, of the German, the French, or the Dutch courts, also applying then for their national law, and usually they will not apply the mandatory rules of Belgium. So that's most important about the legal concept and the legal differences. And I will now pass the floor to my colleague Nick for first and all the overview and discussion of the European Court of Justice recent case law, very interesting, on commercial agency.
Thank you, Jo, for covering the first two topics. Let's now move on to the third one, exactly how it is displayed on the slides. An overview and a discussion of the European Court of Justice recent case law on commercial agency. Because it is a directive, this obviously gives rise to a significant amount of case law before the European Court of Justice. And that case law in the past has mainly focused on two key areas. The first one being whether the agent in question falls within that definition of a commercial agent that is adopted as part of the directive. The second one is being what are the right to and calculation of an indemnity or compensation when the commercial agency agreement has been terminated. As part of our discussion today, we have selected three cases that we want to discuss, recent case law. The first one being a judgment rendered last year on the 16th of September 2021. The second one being on the 4th of June in 2020. And the last one is a little bit further back, but was on the 17th of October in 2013. But we selected that one a little bit further back in the timeline, but an extremely important one, which we will come back and touch upon later. So let's discuss the first one, judgment rendered last year. Now, what was the central question, legal question in that case? It's written in the slide in bold, and it reads as follows: is the supply of a copy of a computer software via a download provided together with a grant of a perpetual license for use considered as a sale of goods within the meaning of the agency directive? This was in fact a UK case, and it came before the Court of Appeal of England and Wales, its civil division, and they enunciated that it was no sale of goods. If you supply a copy of software, if it's done via a download, it's not via a tangible medium, such as on a DVD or a CD-ROM, then the Court of Appeal decided that it was not a sale of goods, therefore not falling under the definition of a commercial agent according to the agency directive. Then this case went up to the UK Supreme Court, and they decided to request a preliminary ruling from the ECJ for this question that is written above in bold. And the ECJ rendered its decision, and they started by pointing out that the agency directive in fact does not define the concept of sale of goods, and to understand that notion, it doesn't make any reference at all to national law. It's also not up to national law to define what is then considered a sale of goods. Therefore, the court in its tradition states that this notion of sale of goods must be given an autonomous and uniform interpretation to obviously ensure a uniform application throughout the entire EU. Therefore, it is as an autonomous concept of the European Union. And according to the court, goods are in fact explained as, on the first hand, products which can be valued in money and are capable of forming subject of a commercial transaction. And then the court applied this to the case at hand, and they clearly state that goods under the agency directive can cover computer software, such as the software at issue, and since computer software on the one hand has commercial value, and secondly is capable of forming the subject of a commercial transaction. Therefore, goods can thus cover computer software regardless of the medium on which it is supplied, whether on a tangible medium like a CD or DVD-ROM, or as is now accustomed nowadays via a download. And last but not least, they also stated that the sale of the copy of the software via download on the one hand, and the conclusion of that user license agreement for that copy, they form an indivisible whole. So what are the main observations from this case? Well, for starters, it is now clear that if you supply computer software via a download, via electronic means, in other words, and if it's accompanied also by a grant of a perpetual license for use, this will fall under the concept of sale of goods under the agency directive. As was mentioned at the beginning, the agency directive was first adopted in 1986, some while ago, and obviously at the time no one was thinking about selling a copy of software via a download, even selling it via a tangible medium like a CD or DVD wasn't possible back then. I think for the older people among us, it was via a floppy disk. But actually the judgment, we concur with this, is actually quite obvious, because likely the protection of commercial agents would be undermined if the sale of software on tangible medium would fall under the agency directive. But on the other hand, the sale via electronic means wouldn't. What would happen, in fact, in practice, is that all commercial software would have to be sold via a download in order to then escape the protections of the agency directive. But it's an interesting case because it raises the further questions of what other digital objects may potentially qualify as goods within the agency directive. And the first thing that comes to mind are the well-known non-fungible tokens, the NFTs, if there is a sale or a transaction regarding NFTs, and it is done via an agent, then the question arises whether this type of transaction is then falling under the protective scope of the agency directive. Clearly, with respect to digital objects, food for thought. That's the first one. Now we go over to the second one. That was a judgment of the 4th of June 2020. Now, what was the central legal question there? It reads as follows: can a person be denied the protection under the agency directive on the grounds that he is unable to negotiate prices set by the principal and therefore does not qualify as a commercial agent? We see in practice that the tasks of a commercial agent are not uniform. There are in some instances agreements which limits the activities of the commercial agent, where he can't negotiate on prices. He has a benchmark, a set price on which he has to conclude the sales, and there are other types of agreements where there is more freedom for the commercial agent, and in fact it does have the power to negotiate the prices. The central legal question is the difference in treatment. Does this also have an effect on being qualified as a commercial agent under the agency directive? Because remind you, at the beginning, when we explained the conceptual differences, we made the explicit reference to the negotiating aspect with respect to a commercial agent. This was a case brought before the French courts, and the Tribunal de Commerce de Paris then requested a preliminary ruling from the ECJ in this respect. And the ECJ went on and stated at the beginning of their judgment that there are, in their view, 3 necessary and sufficient conditions to be classified as a commercial agent. The first one being a self-employed intermediary, obviously. The second one, that he needs to be bound to that principle via a contractual relationship of a continuing character. It's a durable contractual relationship. And the third one, the most important one, is that he exercises on behalf of and in the name of the principal any activity which may consist either simply in being an intermediary for the sale and the purchase of the goods, or both acting as an intermediary and also the effective concluding of the sales or purchases of the goods. And in its judgment, the court once again acknowledged that the agency directive does not define the term negotiate, but states that that definition or that interpretation must obviously have as its objective the conclusion of contracts of the sale of goods on behalf of the principal. And it once again states that this is to be considered as an autonomous concept of EU law not up to the national law to interpret this. And the Court of Justice goes on and states that, yeah, in fact, the purpose of a commercial agent's activity depends on the terms of his contract, which is logical, and that the principle in that contract may prescribe that the sale prices of the goods cannot be changed. They are set for the commercial agent. It does not have the power to negotiate the price. But then the next bullet point is really the most significant and essential part of the judgment, is that according to the court, the commercial agent's main tasks are to bring in new customers and or to increase the volume of business with existing customers. And it goes on to state that in its view, the power to not change the prices of the goods sold on behalf of that principle does not actually prevent this commercial agent from carrying out those main tasks. So basically it's stating what's essential, what's the criterion for a commercial agent is bringing new customers, increasing the volume of business with existing customers. This can involve the power to negotiate, but if it doesn't involve the power to negotiate the prices, that this is not essential to that definition to fall under the agency directive in that respect. So the observations, as I stated just a few seconds ago, the person does not necessarily need to have the power to change the prices to be classified as a commercial agent under the agency directive. And again, the same reasoning here with the possible undermining applies here, as we discussed in the previous case. Obviously, the protection of commercial agents would be undermined if those persons that do not have the power to negotiate the prices would be excluded from that protection. In practice, you would see obviously a wave that all commercial agency agreements would have such a clause that he is bound by set prices and does not have the power to negotiate. And lastly, this judgment does raise the question, which specific acts do qualify as those main tasks? More specifically, which specific acts are to be considered as bringing in new customers and increasing the volume of business with existing customers? Now, what the court has done has given an indication of what is not essential or not sufficient for those main tasks, but the question is still rather open of what specific acts do then qualify as bringing in new customers and increasing the volume of business with the existing ones. And then third but not least was a judgment rendered on the 17th of October 2013. What were here the underlying facts? We had a commercial agency agreement with a Belgian commercial agent and a Bulgarian principal. And in their agreement, there was a choice of law clause in favor of Bulgarian law. Obviously, Bulgaria is a member of the EU, so they obviously had adopted the agency directive, which provides for a minimum level of harmonization. But obviously, as we've seen in the topics discussed by Jo, the Belgian law has a wider protection on certain aspects compared to the agency directive and also compared to the Bulgarian law. And so the Belgian commercial agent wanted to invoke that Belgian law in a dispute it had. And it stated that because it has wider protection, the Belgian law, this actually trumps the choice of law in favor of Bulgarian law, because there is a provision in the Brussels I regulation that deals with jurisdiction, that so-called overriding mandatory rules, these rules of a national law that are considered so important, cannot be derogated from in a choice of law clause. And he wanted to invoke that, and the Belgian commercial agent stated that this Belgian law qualified as such a mandatory provision of law, and therefore trumped the choice of law clause in favor of Bulgarian law. This case was then brought before the Belgian Supreme Court, and it requested a preliminary ruling from the ECJ in this respect. And the ECJ went on to state that the fact that the agency directive is correctly implemented in Bulgarian law does not automatically preclude that the rules on commercial agency of another member state that offers such a wider protection qualify as overriding mandatory rules. In other words, even if there is an EU member state that offers a wider protection, that does not automatically mean that it all qualifies as such overriding mandatory rule of laws. That is not enough. No, the ECJ has developed a sort of test. When can that law that offers a wider protection be considered as overriding mandatory law? That is when the legislator of that EU member state, according to the court, held it to be crucial in their legal order concerned to grant the commercial agent protection going beyond that agency directive. And in that assessment, the national judge, who is competent to assess this, must take into account the nature and the objective of such mandatory provisions. There was a follow-up in the Brussels Court of Appeal several years later when they adopted that test developed by the European Court of Justice, and they came to the conclusion that even though Belgium offered that wider protection, that based on the implementation process, that it couldn't be established, according to the court, that the Belgian legislator found it fundamental for maintaining its order to grant such a wider protection than the protection it is offered by the agency directive. In other words, the choice of law clause in favor of Bulgarian law would stand, and thus Bulgarian law would apply. So this is the overview and a brief discussion. Important, the European Court of Justice gives a lot of guidelines that need to be considered. Excuse me. So we need to look at that case law of the European Court of Justice. Important to assess this in your development of your distribution channels. Excuse me. So now we move on to the impact of the revised vertical block exemption regulations on distributorships. I see we're running low on time, so I'll try to move a little bit more quickly with respect to this topic. So we all know that Article 101 of the TFEU introduces a cartel ban. It is not allowed between undertakings in the European Union to conduct certain agreements, such as price fixing agreements, market sharing agreements that is considered to be affecting or hindering competition in the EU. Nevertheless, the European Commission does recognize that certain agreements, even though on the surface they can have some anti-competitive effects, can also have some pro-competitive effects. That's the reason why they adopted in 2010 the first vertical block exemption regulation, along with its vertical guidelines, in order to help companies, undertakings assess if their agreements fall within the conditions of that vertical block exemption regulation. They are automatically block exempted from the cartel ban. They needn't worry, they are in a so-called safe harbor. And the European legislator has now introduced in 2020 the new or the revised vertical block exemption regulation, which is a successor to the 2010 version and its vertical guidelines. What is the material scope? Very brief. The vertical block exemption regulation only has rules or only provides exemptions for vertical agreements. These are agreements concluded between two companies that operate at a different level of the distribution chain, most often a manufacturer on the one hand and a distributor on the other hand. What is the temporal scope of the revised vertical block exemption regulations? They are in principle applicable to agreements as of the 1st of June 2022. That is because the previous 2010 vertical block exemption regulation was until the 31st of May of 2022. And it will be normally in place for 12 years. However, very important, there is a transition period, which means that existing agreements that complied with the previous vertical block exemption regulations in the 2010 version have the time until the 31st of May to comply themselves with the new vertical block exemption regulation. So now is really the time for your existing agreements to assess whether they should be compliant with this new vertical block exemption regulation. Now, what was the reason why the European legislator decided to update its vertical block exemption regulation? Well, the reasoning is displayed in the quote by the EU Commissioner on Competition, but it was mostly meant to deal with the emergence of online sales and to provide an answer to that. The growth of the e-commerce, obviously, which has taken flight in the last decade. So what are the most significant changes? Again, this is not meant to be an exhaustive list, but rather what we consider to be the most significant changes which you should focus on in first instance. There are some less stricter rules for an exclusive distributorship and a selective distributorship. There is a new hardcore restriction with respect to online sales. There are some tightening rules on the dual distribution, and there has been a clarification on the non-compete obligation. Let's dial in on the first one. So now there are less strict rules for exclusive distribution systems. The first one being, now you have the ability as a manufacturer to appoint up to 5 exclusive distributors in a certain territory or for a certain customer group. This is up from the 1 that previously was installed in the 2010 version. Secondly, an active sales restriction can now be passed on to the customers of your buyer or distributor. What we mean with active sales restrictions is that that's a sale restriction that limits a company to actively approach other customers. In the previous version, that active sales restriction was only limited to the distributor itself. Now you can require that sales restriction will also apply further in the distribution chain to the customers of your distributor. And also there is now an enhanced protection of selective distributors in another territory. Selective distribution system, as opposed to exclusive distribution system, is that in a selective distribution system, you select your distributors based on a certain number of qualifications. In an exclusive distributor system, that is not really the case. Now you can prevent both sales and active and passive sales of exclusive distributors to conduct those sales in the territories of selective distributor system. So you can have a coexistence. In one territory, have an exclusive distribution system, and in another territory, the ability to select or have a selective distribution system. Then the less strict rules for the selective one, the protection of exclusive distributors in another territory. This is actually the inverse of the last one I discussed, and that exclusive distributors can also be protected in their environment against the selective distributors in another territory. And also the active and passive sales restriction can be extended to the customers of that selective distributor. And also there is now the matter on equivalence. That means that now it is permitted to have different requirements or different qualifications for an online distributors versus a distributor that acts in physical shops. In the previous vertical block exemption regulations, these requirements had to be the same, but now this has been abolished. Then there are new more strict rules on dual and on online sales. I refer you to the slide here because of time constraints. You still need to go to the key takeaways. But now there are some stricter rules on online sales that need to be taken into account. Also, tightening rules on dual distribution. Again, I kindly refer you to our slides. And then the last one is also a clarification on the non-compete obligation, which is limited to 5 years, but is tacitly renewable after those 5 years if there is a mandatory renegotiation of an agreement in place or a right to terminate an agreement with reasonable notice. We also still had another poll question planned, but I see we are running a little bit low on time. So we'll skip this one, and I kindly now refer you back to my colleague Jo for the key takeaways.
Thank you, Nick, and also for respecting so well the time. I know that's of essence for everyone. So the key takeaways, then we move on. The first one is to map your distribution channel and really determine first whether cooperation is, of course, a commercial agency, what's a qualification, or a distribution. And we have learned that for commercial agency, it's more easier. There's an harmonization at the EU level with a wider protection possible. There's a minimum harmonization, but please check what's the national law specifically stating with regard to the commercial agency. For the distributorship, we have seen there's no harmonization at all at EU level, different rules which you have to take into account. And there can be, like in Belgium, onerous obligation for the termination of a distributorship of an indefinite duration. There was also one question I saw when there is a clause or an agreement for 3 years and it has been tacitly renewed with 1 year. Then there's also an exceptional rule in Belgium that after a third renewal, this agreement will also be considered to be of an indefinite duration and the legal regime will apply. So I think that question has been answered then also as well. Be aware, based on the case law of the European Court of Justice, that the scope of commercial agency is quite broad. It's not only the sale of physical, tangible products, but also digital products, as Nick has pointed out. And it's not only the power to negotiate price is not required to qualify as a commercial agent. Whenever you do what you do, your task is to increase business, then you can also qualify according to the European Court of Justice as a commercial agent. And with regards to the VBER, that's important that you have to update your existing agreements until you have time until 31st of May next year. And if your agreement meets the conditions, then you automatically block exempted. So please check that as important, and the vertical blocks exemption has important consequences or may have for your distribution agreements. So that's in a nutshell what we want to share with you today. And then I thank you for your attendance, and I please hand over last time to Bruno for his final observations. Thank you in advance.
Thank you, Jo and Nick from Lydian. Effectively, it was a very good, for some of the element, refreshing and also some kind of learning. And it's always very important for us in-house lawyer, because when we are in an acquisition mode or when we are reviewing on a regular basis the portfolio of distributors that we have within our company, it's always good effectively to give the appropriate advice to our internal client in terms of, okay, in this country, you'd better have a strategy to welcome or to exit a distributor, because it can be very costly for the business. So with that, I will just going to recall to the audience that we will be organizing more seminars, hopefully in person, but also webinar for the rest of the year. Maybe also a few social events together with my colleague Christina Alexandru, the co-organizer of ACC for Belgium. And one more time, last reminder, book your calendar for the ACC Europe Brussels 2023 conference between 16 and 18 of April. So with that, I wish you a good day, and I guess we are just on time at 1 p.m. So thank you. Bye-bye. Have a nice day.